Today, I wanted to cover one of the canons of statutory construction called the Constitutional Avoidance Doctrine. For purposes of statutory construction, the courts and bill drafters use a series of canons to guide them in interpreting statutory language. These canons include textual canons, which we refer to as intrinsic aids, as well as linguistic presumptions, grammatical conventions, substantive canons, and extrinsic aids. Now, it's nearly impossible to list all of them, but there are a few common canons that are most useful for legislative drafting and interpretation. We start with the presumption that the legislature drafts its bills carefully and intentionally. And because of this presumption, the usual approach of the judicial branch is to narrow statutes rather than expand them, and the courts are less activist in their interpretation. There are also so-called clear statement rules, and these are canons that the United States Supreme Court first developed as an expression of quasi-constitutional values. For example, under the Constitutional Avoidance Doctrine, or canon, statutes will be construed, if possible, to avoid questions about their constitutionality. In these cases, the courts do not have to find that the statute is unconstitutional, only that it could raise a constitutional issue. Most commonly referred to as just the avoidance canon, it's when a possibly acceptable construction of a statute would raise a serious constitutional question or problem for the statute. And so a court's going to construe that statute to avoid any such constitutional problem, unless the construction is plainly contrary to the intent of the legislature. So the fundamental principle of the constitutional avoidance canon is that a court should interpret the Constitution only when it is strictly necessary to do so.